Hey y'all, welcome back to my channel. If you're new here, hello. If you feel like you got a little bit of that common sense that's not so common, go ahead and hit that subscribe button. And if you don't, common sense is a disease that I'm trying to make highly contagious, so go ahead and hit the subscribe button anyway, okay? And today on this channel, we're gonna be looking at House Bill 885 in Tennessee, which is the Prior Authorization Fairness Act that will be going into effect on January 1st, 2025. All right, and people remember, I'm common folk. I ain't got no official law degree. I don't have any official law training. I get all my information from Dr. Google and then give it to you guys with my opinion. But before we get any deeper, first and foremost, my name is Key and this is What's the Key?
For me, break, for me, break the body for me.
Now y'all, tell me why I had to re-record this video because Miss Bougie House Bill 885 that we about to get into took so long. Like, if I don't cut her out and make a whole separate intro, like separate video for her, it's gonna be too long. The video gonna be over an hour. So I had to create this whole entire new intro just to let a little girlie in here, okay? So she got her own show. But enough of all that, let's get into it. As always, if you see me looking down, looking at my notes, any bell you're hearing is my cat City doing kitty thing. Don't forget to like this video because y'all gonna forget to like it on the way out, all right? Let's get into it. The first one is House Bill 885, and this was an all-Republican bill. And this is the Prior Authorization Fairness Act. I'm gonna put the name of the people who sponsored the bill here. And what this bill is doing is providing requirements for initial adverse determinations, okay? If a utilization review organization, we're gonna call that URO for the rest of this video, makes an adverse determination for prior authorization of a healthcare service, then the carrier or organization shall include the following in the notification to the enrollee's healthcare provider requesting the auth on the enrollee's behalf. They have to give the reason for the adverse determination, if applicable, related evidence based on the criteria, including a description or any missing or insufficient evidence that was given. They have to give the right to appeal and instructions on how they can appeal, and then they must provide all documentation that is needed for an appeal when they send the adverse determination. Determination must be made by a licensed physician or a healthcare professional. And if I find that clip, I'm gonna put it in here. Do y'all remember back? And I believe it was the Illinois bill video. I said a lot of these could be solved if they would just put doctors and stuff in the front. If we can't say anything about insurance companies, we can say this. They are clearly not ran by actual doctors. Clearly. And I feel like if we just make that a federal law that insurance companies can only be operated by medical professionals, hospitals, etc., we might see some changes because this shit is a little ridiculous. Tennessee is doing that, okay? So we're gonna track Tennessee, see how the people in Tennessee feel about their health care and stuff after this goes into effect, and if this is actually helping them make decisions, or do we got some corrupt doctors out there that's only looking for a dollar as well, okay? The first thing, all right? Determination must be made by a licensed physician or a healthcare professional with the same or similar specialty as the healthcare professional requesting the authorization. They said, look, same specialty. Listen. Meaning you a foot doctor, don't tell that heart surgeon he can't have that prior auth. How you know? I love that, all right? And this is not applied to an initial determination for prescription drugs that are covered under an enrollee's benefit plan. Like I said, I love this. I'm really hoping that the doctors get together and really make sure, like, okay, we for the people. Because as far as I can tell from how the, doctors, physicians, nurses, and stuff give it out to us, and coders lay stuff out, they really do try to get stuff covered under insurance because they're like, it doesn't make sense. How are you able to tell me no, and I'm the doctor telling you yes? They need this, okay? I love it. Next section, appeals for electronics and non-electronics for the initial adverse determination. So for the ones submitted electronically by the professionals with the same specialty and the reviewing professional, okay, they must both possess a current and valid non-restricted license to practice in the state or another state or territory in the U.S. So they have to be licensed within the U.S. They have to be knowledgeable of and have experience providing for healthcare services under appeal. I love that. They said, look, we understand that those that do teach, but you're gonna have to do over here. You're gonna have to do over here. All right, so they said, I don't want nobody that just read a textbook and said, hey, I don't think this goes based off the textbook. The doctor that's been working the field for 20 years said, we need this, this is what goes, okay? And another experienced professional that knows is like, yeah, I did this. You definitely need that in order for this to be, if you want it to go smoothly, okay? So I love that. They said, we need you to have experience around here, okay? No textbook doctors, straight out of school. So they have to be knowledgeable and have the experience of providing healthcare services under the pill. They also have to not have been directly involved in making the initial adverse determination. So they can't be the same doctor that said no in the beginning. And they must consider all known clinical aspects of service under review, which can include them requesting any medical records or reviewing any medical literature they find is needed to make a determination. So the URO organization shall perform a non-urgent prior auth review within 7 days and an urgent one within 72 hours plus 1 additional business day if needed. The carrier or the URO or the healthcare professional on its behalf shall not receive compensation as an incentive for assuming and for issuing AEDs. They can't say, hey, you get a bonus for every determination you deny. You can't receive bonuses for denying these prior auths. Listen, and that's a good one. That's a good one. You'll be more inclined to deny a prior auth if you know you get a bonus out of it as opposed to when you approve it, okay? Money makes people do things even if they don't want to. Money makes people do things. For one submitted non-electronically, it must be in accordance with the standards set by the National Committee of Quality Assurance. If it's submitted via FACI-Smile, it is not considered electronic. I hope I said that right. FACISMILE. So the next thing, we're going to get into some of these prior auth submissions, all right? So if a prior auth is submitted in those 7 days and hasn't been approved or denied within those 7 days, it's automatically approved, okay, from the date of the submission. And if they fail to request any additional info needed to make the decision, or except for a prior auth prescription drug, fails to notify the provider, the auth is being questioned for medical necessity, okay? So if they didn't say that they needed additional information to make the decision, and then they also didn't tell the healthcare professional submitting the request, hey, this is being questioned, it is automatically approved within that 7-day time frame as well. So they can't be like, oh, well, we needed more information. Nah, 7 days passed, it's approved. I like that they did this. So no BSing, no holding people back, no taking forever, no taking a month, no, we haven't heard back from the insurance company. Okay, y'all got 7 days for anything in general, and anything urgent is 72 hours plus an additional business day if it is needed. Okay, Tennessee says stop playing with people. Tennessee Republicans says stop playing with our people in their healthcare. They paying y'all $200 to $300 a month. Act like a damn healthcare company. All right. So the URO also has an additional 5 calendar days to process, and yeah, that's nothing. It's calendar days, not 7 calendar days. They said, we know y'all got people working on weekends, stop playing with us. Get these offs in. Get them approved and denied, let them know so they can appeal them. Make sure you got a licensed professional doing this. The Republicans don't be having just anybody out here denying. Okay? To process prior auth, once provider sends additional information. So they get an additional 5 days once they get any requested documents that they need. So if they do provide any notice that they're going to be questioned about what they submitted, they must include on this notice the direct phone number of the URO and any mailing address, and the hours of operations of the physician that is making the decision on the appeal. And they must include in a statement that they say, hey, you can discuss this with the medical professional that is reviewing this. So that doctor, that healthcare professional, etc., gets to talk to the other healthcare professional in the same specialty field if they have any questions, if they're anything like that. They put a statement in there, you are allowed to speak to them about the whole review process. So if the notice complies with what I just mentioned above, they have 17 days to get the additional documentation and anything submitted. And if they don't get their documentation or anything that was requested, anything that was additionally requested sent in, then they have to send in the new prior auth. And I 17 days is a lot of time to me. And that includes, I'm assuming they do 17 days because maybe they're requesting, hey, can we get this lab? Can we double check these numbers? Can we check this report? Because it is somebody in that same specialty field, so they would know exactly what to request and know that it will take some time to get. And if you can't get it in 17 days, half a month, then yeah, a little over half a month, yeah, go ahead and redo the request. You're wasting people's time at this point. So for an urgent prior auth, it's the same thing. The urgent prior auth is considered approved if not approved within the 72 hours plus the one additional business day that we talked about. But the provider must submit any requested documentation also within 72 hours in that one business day. So they have to be just as, if you want this urgent, you need to be as urgent with us. Can't be taking forever. I like that. They don't approve or deny this claim. Once the documents are submitted, it's automatically approved. And if they don't submit any of the documents within that time frame, they must submit a whole new urgent prior auth, okay? And then for any carrier that provides coverage for ER services, they cannot require prior auths for ER services because it's emergency care. Like, you can't move fast enough for emergency care, okay? You can't. We can do it as we're trying to help people, but you can't move fast enough for emergency care. So any healthcare professional making the request must submit the request for the prior auth at least 5 calendar days prior to provision of service or therapy for non-urgent. So they have 5 business days. Or 5 calendar days. They have 5 calendar days. So this section only applies to electronic submissions unless the URO or carrier does not allow electronic submissions. So I wonder if that's what I'm saying, okay, you don't want to go by that timeline, so you took away being electronic submissions. Well, even if you don't provide it, you still are under this same time standard to get the fax machine out. That makes sense. I like that. Because like you can see them. I mean, all you got to do if you want to deny things, make things more delayed, just take away electronic submission, make everything have to go through manual. It'll make things a lot harder. So I like that they put that in there to say, hey, if you decide to take that out, it's not part of your standard. I think what they are saying is you are still part of the standard. Okay, if your electronic isn't even an option. All right, chronic conditions. For chronic condition prior auths, they must remain valid for at least 6 months for the provider professional unless clinical criteria, which I'm going to get into next, specifies otherwise. This includes any prescription drugs for that chronic condition. I like that. People have chronic conditions. You ain't got time to keep having to get a prior auth every time it's time for a refill, every time it's time to get a test that is normally identified with that chronic condition. So I love it. It makes sense. See, I love when the government thinks of things I wouldn't even think of. This is why they're the lawmaker. This is why y'all got the degrees. That's why we voted y'all in office. Some of y'all, we starting to get a little less educated each time we vote newer people in office. But I digress with that. This does not apply to Schedule 2, 3, 4, or 5 drugs, but the notice must be provided that the prior auth must be required. And it also does not require them to cover anything that's not under their policy. I like that they have to throw that in there because you will have that person that will try to fight it. You will have that person that tries to fight it. So I like that they put that in there. All right, clinical criteria. The healthcare must maintain a list of services for which the prior auth is required. And the clinical review criteria must be based on, I'm already liking this. You gotta let them know, hey, don't let it be a surprise every time we get in there. If we submit this to you, it's because it's on your list and you need to do it. I love it, okay? Clinical review criteria must be based on nationally recognized and generally accepted standards for national clinical criteria, except where state law provides its own standard. It must not be arbitrary. It must be cited by the URO. It must be developed in accordance with the current standards of national medical accreditation. It must ensure quality of care and access to needed healthcare services. It must be evidence-based. Having to put that in there is crazy because you would think, but then you think about the average person. Everybody won't argue off their evidence. They argue off their feelings and opinions. And it must be sufficiently flexible to allow deviation from norms case-by-case basis. That makes sense. Everybody's not the same. The body's different. People react difference. Just because they have this one disease like this other person have doesn't mean they don't have any other prior conditions or anything like other diseases that could be affecting their disease, as well as this person that may just only be suffering from this only disease or chronic condition or etc. So I do like that. And it must be evaluated and updated according to 56-7-3618. So they're like, keep your standards up to date. A claim to failure to obtain prior auth must not be denied if the prior auth requirement was not in effect on date of service of claim. So they're saying if you didn't have the requirement for a prior auth to try to put it afterwards, you can't all of a sudden tell them, hey, no, we're denying this claim because you need a prior auth now. We now require a prior auth. They said, nah, you didn't need a prior auth at the time. It wasn't put in place, or they put in this claim, so pay it out. I've actually heard of situations of them doing things like that, of them submitting something, they're like, oh, all of a sudden this one needed this before you could submit it, this needed that. Good job, Tennessee. Tennessee, them Republicans that's been doing this bill, they were like, listen, okay, we've been dealing with this shit personally. I'm surprised. I'm kind of like, I know Tennessee's a more Republican state. I'm surprised more Democrats weren't on this bill. Not on the Senate bill or the House bill side. I didn't see any D's for the names. All right, electronic prior auth. You will accept and respond to electronic requests. The fact that you have to put that into law is crazy. All right? If prescription prior auths are submitted electronically using the National Council for Prescription Drug Program script transactions, they must be accepted and responded to. This section does not make electronic submissions a requirement. So you don't have to require things to be submitted electronically, but if you do, then this, okay? So a prior auth doesn't expire until at least 6 months from the date of approval. For prior auth and opioid use disorder, URO, and the provider should not require a prior auth for prescription drugs labeled by the US FDA, which is the US Federal Drug Administration, for treatment of opioid disorder, okay? This section does not require a policy to cover anything that is not included, all right? So you can't go in and say, well, I got this disorder and stuff. It's not included in your plan. They don't have to all of a sudden require it just because it's in this law. And this also does not apply to behavior inpatient services. Sometimes you ain't got time for a prior auth, okay? Personal experience. The medical necessity must comply with the Consolidation Appropriations Act of 2021. Restrictions on emergency care or emergency health care provided by a non-participating providers must be greater than restrictions that apply when participating providers provide those services, okay? So now we're gonna get into the changing of prior auth requirements. If any URO is planning to change their requirements, they must provide a notice of the requirements of the new restrictions for in 60 days in advance, at least 60 days in advance. For any prescription drugs, it's 45 days in advance unless the US FDA has stepped in these types of ways and, change that standard. Issued a statement regarding clinical safety of the drug. Required manufacturer to conduct past market studies and clinical trials after the approval of the drug. So that can also extend the drug being used. Because a lot of doctors, a lot of them are tracking some prescriptions. They see prescriptions, especially the ones that are specialties in their fields. And they're like, okay, this drug could be great. It's based off the clinical trials and things like that. So yeah, if anything comes out at the FDA after the fact, you do need to, they could delay it because there could be a case where there are doctors waiting for that moment for it to be approved so they can give it out to the patient. If the USFDA has issued any drug safety related label changes, that makes sense, and it has to be reviewed. They require the manufacturer to implement special risk management programs. That could also make it delayed because now that'll have to be included within the prior auth. Also, if the drug hasn't received new approval from FDA and drug admin has become available, the FDA has approved extended use of the drug. So none of those that make sense. The FDA put it out, so the prescription companies shouldn't have to. Doctors and everything, hospitals should be looking at what the FDA is putting out. At least their pharmacies, at the very least, should be looking at this and should be telling the doctors deny that drug is no longer available, etc., etc. Now that I think about it, it's gonna have to be the pharmacies and the labs and stuff like that. I don't know if the doctors and stuff ahead of time or pay attention or notice. So for the notice that is required, it has to be distributed through the URO's website or the provider portal, whichever option they have. And a written communication has to be sent to a dedicated email address and regular mailing address for the provider or as stipulated in the contract between the healthcare provider and the URO. The provider may be required to submit an email and mailing address to the URO at organizations for this reason, which you should give them your information anyway. They should be able to have contact with you if y'all have to talk back and forth for people's authorizations, prior authorizations and things like that. Payments. A carrier or UL shall pay provider at contracted rate per approved prior auth unless the provider knowingly and materially misrepresented the service and prior auth with specific intent to deceive and obtain an unlawful payment. The provider was no longer contracted with patient's health benefit plan on date of service was provided. So I know a lot of doctors, they have to get approved with like each individual insurance company in order to provide services and for them to be able to submit prior auths and claims to that insurance place. So I get that. The provider failed to meet timely filing requirements of carrier, okay? So in that case, they just submit a new prior auth, that way everything goes on time and they can get paid. Like, I feel like if they don't submit anything in the time requirements, the entire prior auth would just be denied anyway, so they wouldn't even be getting what they asked for in the first place. So that makes sense. All right, the carrier should pay the provider for performing service if prior auth for service was obtained by another provider. Okay, so if another provider, of course, in that specialty field, obtained the prior auth, and another one provided, you still have to pay the one that provided the service because another, the professional obtained it. The carrier should provide reimbursement for services retroactively deemed medically necessary, regardless of when prior auth was approved, for a max of 18 plus months. Okay, that makes sense. Payment must be guaranteed when the prior auth is approved, and this does not apply to prescription drugs under an enrollee's plan. All right, y'all, I still have 2 more pages. This is a longer one. This is why I did this one first, okay? Because this is going to be the longest one. Prior auth transfer. Upon receipt of info documentary, a prior auth from the enrollee's provider, a prior auth granted to an enrollee from a previous URO or carrier must be honored for at least initial 90 days of enrollee's coverage under new health plan. I like that. Because when you switch your health plan, it should be, most of UROs should be making decisions based off the same kind of clinical, knowledge anyway. During those 90 days, a carrier or a URO may perform their own review to approve or deny the prior auth approved by enrollee's previous plan, effective when 90 days expire. So in that initial 90 days, they can't do anything, but they can review it and decide after 90 days in this new plan, no, we're not approving this prior auth anymore. And hopefully they have to give the same reasons for any other reason they deny a prior auth. The easiest one would be it's just no longer included in the plan. If there are any changes in coverage or criteria for approval, it cannot affect anything prior auth for the remainder of the benefit plan. So if they decide to say, hey, no, you gotta start adding this in now, you gotta add this in now, if you've already approved something for them, for the remainder of that benefit year, you cannot just all of a sudden take it away. It was approved when they requested it, they gave you everything you needed. You added stuff afterwards, but it doesn't matter. It was approved with all the proper things that they were supposed to give you before. So it stays approved for the rest of the benefit year. I love that too. Now insurance companies can be like, dang, we're approving a lot of these. How can we make this harder? And then to start denying people and saying, hey, we take this away because now I've seen that. I've worked in the medical field. We no longer carry this, so now it's denied. The medication or something is denied this month. Like, what? Or this criteria, you no longer meet the criteria for it, so now you're denied. Like within the same, yeah, I've seen it. Carrier URO should continue to honor a prior auth and it has granted to enrollee who received prior auth when they change plans carried or administered by the same health carrier. Okay? That makes sense. Same carrier, so the same it should be same people, same requirement. You should be good. Related service. An URO should not deem as incidental or deny claims for supplies or health care that are routinely used as service when their closely related service has prior auth. The prior auth for the service is not required. Reviewer criteria. Carrier is responsible for monitoring all URO activities performed on its behalf for ensuring that all requirement of this chapter and application rules are met. The carrier should ensure that the application personnel have operational responsibility for the conduct of the UR program. I love that they're putting the carrier in responsible of the UR program. I like it. Because the carriers, they have been the conniving ones. Okay, so if they decide to get an additional, you're responsible. You will always be. I like it. I'm okay with that. Whether a carrier contracts with the URO to perform their services subject to above, the commissioner shall hold the carrier responsible for monitoring activities of such URO and for ensuring that the requirements of this part and applicable rules are met. So any of these third parties y'all hire, Yes, you must make sure they're under state law for you, okay? Because they're working under you. I get that 100%. A URO shall be using clinical criteria or statistics. The carrier or URO should make statistics available by service code regarding prior auth approvals and denials on its website, readily accessible format. All right, so no request this and you receive it in 2 to 3 bits. Download right now. All right, commissioner determine the info required in order to comply with the state or federal laws. Some such statistics are included but are not limited to the number of initial prior auths to request approved or denied during the previous benefit year by carrier URO. I like that. I like that. Number of prior auth requests that were appealed. That'd be funny. What if they say we had over 30,000 requests and 29,950 were appealed? That'd be hilarious. I think this would be good numbers too, because it'll have people looking at insurance companies like, I don't think I want this insurance company. They deny everything. Why am I paying you $200, $300 a month? And you're denying everything. I like it. The time between the submission and response for initial requests, the top 5 reasons for a denial, and the average time between submission and response for initial prior auth requests, and the appeal of denial. So they want to know that time that it takes for the entire process. Submitting and responding. How long does it take you as a company to usually do this? Because then you can start seeing, does it usually take you up to 6 days all the time to finally respond? Are you always going up to that 7-day window? Are you being an asshole? I like it. Then in the commissioner, any info that the commissioner deems appropriate, they can either add in as well. Prior auth requirements. The carrier or URO must at least annually review its prior auth requirements and consider removal of a prior auth where a prescription or medical service check is customary and properly indicated or is a treatment for clinical indication as supported by peer-reviewed medical publications. So if you know this is something that is now being commonly used and people have supported this and say, yes, this is used for that, take it off the damn prior auth list. They should need a prior authorization to do it. You know it's used. So why are you, it's not it's not early stages. It's not something that's new. It's not something that's abnormal for this treatment. It's literally something that's common. So go ahead and approve it. I like that. So the website notice requirements. The carrier URO shall make prior auth requirements readily accessible on the website. I love that. I love that. The site must indicate each service subject to prior auth while satisfying the following. They must put lettering notification for each service in bold and indicate when the authorization became required. And also if the authorization has been terminated, the date it has been terminated. Alright, they must identify the Tennessee specific date. So if you all of a sudden started making it a requirement in Tennessee, you gotta put the date for it. You gotta provide the date that it was removed from Tennessee as well if it's no longer applicable in the state of Tennessee. And they must provide access to standardized electronic prior auth requests if it is applicable to them. Remember, they don't have to have electronic submissions. Alright, so who does this all apply to? Insurers providing a healthcare plan that pays for healthcare services to cover the persons, and healthcare plans including the ones made by the state. All right, state healthcare plans are part of this too. It's not applied to plans subject to exclusive jurisdictions of the Flood Employee Retirement Income Security Act of 1974. All right, something we updated. All right, policy of insurance issued pursuant to a contract with the Bureau of TennCare. So TennCare is kind of like their Medicare or their own version of Reliance in Tennessee, and we'll get into some other stuff later with them. All right. TennCare are the successor program, and then Cover Kids are the successor programs for the Cover Kids Act of 2006. So for any notifications to the carrier, if the carrier provides a provider to notify the carrier that an enrollee has received a service or has been admitted, such notification should include, if applicable, 1 additional business day if the deadline falls on a weekend or state or federal holiday. All right, and then the rules commissioner can add any rules that they feel fit. So that is good. I feel like they went even deeper than I believe it was the state of Illinois. It had even more details for prior auth. So I like that. We're going to realize that a lot with the Tennessee bills. They are very detailed, and I like that about it. They're making sure they don't miss a thing, and you can't argue. It's like, after we pull this out, we don't want to hear your mouth. All right, so they put in everything that they need. I like it. Their bills are very detailed. But y'all, that brings us into the video. Let me know y'all thoughts on this Prior Authorization Act. This Prior Authorization Fairness Act, okay? Do you think it's fair? I'm excited to see this go into effect. Like I said, I'm ready to track this bill. All right, I'm ready to track the people in Tennessee and kind of see their opinions on healthcare and whether they're getting approved for things they were usually getting denied for, and etc. Once we have these healthcare professionals in the same specialty denying or approving. But don't forget to like this video again, and I'll talk to y'all later. Bye.
For me, break, break, for me, break the body for me.